So the purpose of today is just to give you a brief overview of the International Arbitration Expert Program. So I'm the course director for this program, and it's done in association with Fenwick Elliott as well as the Expertise Institute. So as partners together, we're presenting this course. So in brief outline, you've probably seen the materials, but it's a 12-week course. So the main part of the course is a 1.5 hour online lecture for 12 weeks, one each week. But in addition to that, there will be 4 tutorials, also of an hour and a half, that will be every sort of third week approximately, in order to give you more time to focus on a particular topic and work with a trainer in order to consider how to deal with this particular topic in a bit more detail. So you get the lectures and you've got these workshops. Materials will be provided, and also a number of short videos to give you extra learning as well. We've done a similar course to this in the past, and it's based upon what you would expect really for a module of a degree, really. So the idea is to give people a chance to learn properly, rather than simply have some talks on international arbitration. So that means that the course is structured then in the same way that you would approach a course on international arbitration at a university. And the topics are the same topics, but of course we can only go into them in so much detail compared to, say, a master's. But nonetheless, we aim to pick up the main points, the main topics. And so if we just look briefly at the 12-week period, the first one is an introduction to arbitration. This is about giving an overview and looking at the benefits of arbitration compared to going into a local court, particularly for construction. We'll compare it to some other methods of dispute resolution. One of the key areas, of course, of arbitration is that it's confidential, and so the parties don't have all of their dispute being aired in the court and in the newspapers, and that's quite important for high-value infrastructure projects. And the importance of the New York Convention will be considered because that's one of the most fundamentally widely used conventions around the world for enforcement directly in a court in relation to an arbitration award. And I'll take that session to kick everything off. Then we'll look at applicable laws and rules. So, of course, you need to think about where you're getting the laws and the rules if you are in arbitration, because if you go to a local court, then you know what you're going to get. You're going to get the local laws and local rules. But in arbitration, you could select the substantive law for your contract. It doesn't need to be the law of the place. And this can mean you end up with a variety of different legal systems having an impact on your dispute and the process. So we'll explore all of that. There's also the ad hoc rules and the institutional rules like the ICC and LCIA. So we'll have a brief look at those, but dedicate some time in the tutorial to those to make a comparison, really, which is a nice way of looking at it. The arbitration agreement comes next, and the validity of it, the requirements for it, issues like separability, if you've never come across that before, will be looked at. Problem arbitration clauses, which are quite common, they're called pathological arbitration clauses. We'll look at all of these important key topics. Then we'll move to focusing on how you commence an arbitration. In other words, how you refer your dispute to arbitration, and then the appointment of the arbitrators. And typically 3 is very common, but you could have a sole appointment, but 3 is more common for large projects. And this would mean that each party makes an appointment, and then a chair or a president is found in order to run the arbitration. Now, you can have procedural challenges here, issues about impartiality or disclosure here, and sometimes it can take quite a while to get an arbitration started and moving forward. So we'll look at all of that. Another tutorial will pick up on selecting the tribunal and the types of skills and qualifications that you might want. And that's a good workshop topic, because you'll all have your own views about this, and you'll all want to ask questions, make your own points, and it's quite interesting to see what everybody thinks about what's important in relation to selecting the tribunal. Then we'll look at the jurisdiction and therefore the powers and the obligations of the tribunal. Because, of course, once they have jurisdiction over the dispute, then you're interested to think about what powers they have to drive everything forward, but also the obligations, because they have an obligation to move the dispute forward efficiently and practically, and also write an award that should be enforceable. So it's not just about them having powers as arbitrators. We're interested in their obligations and what they have to do as well. We'll look at the emergency arbitrator, which has developed in more recent times. And this is for lower value disputes potentially, or also something that's extremely important that needs preserving now. So, for example, if you're trying to preserve documents or steps need to be taken in order to preserve some evidence or get access to the site, then this might be appropriate. Unfortunately, the powers of an emergency arbitrator are quite limited because they're an arbitrator and not a judge. So we'll look at that and we'll explore how people have been using that and where it's been successful and where you can use it and where perhaps it doesn't work. And then we'll have another tutorial on jurisdiction because it's quite an important area to have a look at. After that, we'll move to the process itself in a bit more detail. So the first key one is interim measures. What orders can a tribunal give in order to require parties to produce more documents or produce witnesses? And can those interim measures be supported by local courts so that in fact they work? And we'll look at that relationship there between the arbitrators and the court. We'll also then move on to think about multi-party arbitrations, which can be perhaps more common in construction than other areas. And it's quite difficult really to have a multi-party dispute unless everyone has signed up to the arbitration clause. So we'll look at a bit of that to start with, but we'll also think about other ways of bringing parties in, which can be quite difficult and limited. And the main thing here is joining parties into an existing arbitration, or whether you start a couple of arbitrations, then consolidate them into one. So we'll look at what all that means and how you might decide what is the best way forward. Then we'll look at the proceedings themselves, because there are several ways to move an arbitration forward. A moratorium style is to have everything together at the very start. So the claim and the documents and the experts' reports and so on. Or you may follow the process of having the pleadings first and then documents and an argument about documents and maybe experts' reports and witness statements later. And then, of course, there's the managing and the dealing with those documents and the experts' role and whether you hot tub experts or not potentially as you move towards the hearing itself. And we'll explore the hearing, of course. Then we'll look at the award. What needs to be in the award to make it valid, how you might go about drafting one, and then recognition and enforcement of awards, because there's two real issues there. One is the award complete and does it deal with everything? So you can make sure that the award is right and proper and correct yourself, and that's important for the arbitrators and the parties. But then the next thing, of course, is whether the local court is going to enforce it, and that's another whole host of issues that we'll consider. The final tutorial will have a practical go at some key aspects of drafting an award, so you'll have a chance to think about that practically. And then we'll finish with investment treaty arbitration, which is becoming slowly more popular with construction disputes. And this is where a business operating in a country brings a claim against the government of that country because of its inability to get a return on investment in that country, because the country has taken a different approach to foreign businesses compared to local businesses. So you can see that's probably quite limited, and it certainly used to be, but it's becoming more of an avenue now. So we've included that because it's an important area. Now, the other nice thing about this course is you'll hear from me a few times, certainly 3 times, I imagine. But I'm not going to teach it all. I've got my friends, brought my friends along, and I think that's one of the nice things about this course. So Professor Mohammed Abdul Wahab will give a session, and he is, in my view, one of the leading international arbitrators at the moment. a fantastic visionary, well regarded, has done many arbitrations in many places. He's the founding partner of his business in Egypt. He's a professor and at the Cairo University, a chair of the ICC governing body for dispute resolution, and the current president of the Chartered Institute of Arbitrators. He's supremely well qualified, and we're very lucky to have some of his time. John Beachy, CBE, will join us. He has joined because when I was chair of the expertise committee at the ICC, he was president of the arbitration commission where I sat as vice president. So we know each other from a long time back, and so he's agreed to come along and take one of the sessions. A very knowledgeable character. Professor Doug Jones, very well known internationally for construction disputes, was a lawyer with 40 years experience in Australia, but doing international work. And then as he sort of reached the end of that point, he decided to become an arbitrator and focus solely on that. And he's very well known for independent international arbitration rules and also investor state ICSID type arbitrations, and acting as often the president. Andreas Calivaras will join us, a partner in a law firm in Italy, Bonelli Aredi, an international law firm, but he was also past a president at the ICC, another very well qualified individual. Peter Turner QC, a barrister at Essex Chambers, only doing international arbitration. Annalise Day, another KC from London, doing construction, but a lot of international arbitration work. Kelvin Orr, and he's a partner and co-head of infrastructure and construction at CMS in Singapore, and a past student of mine 20 years ago. Alice Gambato will also be taking one of the sessions in relation to this course. And then finally, Michael Black, KC. He's a judge in the DIFC Court of Appeal, so has the grand title of His Excellency, Judge Michael Black, a fantastic international arbitrator. And then, sorry, finally, we do have Winnie May, and she is an international arbitrator based in Australia, but has a lot of experience in Asia. So we're covering the world very much, really, with the people that we have and the experience that they have. So that, I hope, gives you a flavour of it, and I've taken 15 minutes approximately. We've got another 15 minutes. So if any of you have got any questions at all about the trainers or the topics, please let me know. That's what I'm here for. Just turn your mic on and speak. Is pretty easier than trying to type. Don't be shy. So while you're thinking, the course begins in mid-Jan. I may have said it's an hour and a half each session, and you can join online. Those are programmed every week. A couple of them change times in the day to suit where people are based. But hopefully this means you can program it into your work or personal life at whatever appropriate time of the day. As for the videos, of course, you can just watch those whenever you want. And the reading materials, of course, you can just read those whenever you want. And the idea of the videos and how the materials is so you can supplement your knowledge. So when you've got the slides and you've listened to the lecture, there's some extra material. You know, of course, there's plenty of books out there on international arbitration, and we'll suggest a few in the course starts that are good. And there's a lot of stuff on the internet about it, but some of it's good and some of it's very unstructured or not very clear. So our aim is to focus on the key topics. As I say, based on what you would be taught in a course, and following the structure of the key books that are available. So Born is one of those. Um, and Redfern and Hunter is another one. And if you look at any of these books, you'll see that they have a similar structure to the one that I've adopted. I've adopted here. So over to you. Any questions? I'm looking at the chat now. Sorry. Okay. Okay. Now I've got access to the chat suddenly. Brilliant. Dearie me. All right. Okay. Okay. So you can't have the audio on. Sorry, I haven't realized that. Can raise their hands. All right. Okay. Uh, is there a limit to the number of people? Yes, there is. Um, the maximum is 38. But as this is a new course, we might end up limiting it to 28. It depends, but certainly it'll be limited. And we found that by limiting the number of people, we get much better interaction. You get a chance to ask questions with a smaller number of people, so that tends to work quite well. Exams, well, there's two essays to write, two assignments. And the first one is marked but doesn't count. It's just to give you a feel for what it's like to be a student again, for those of you that aren't sure. And then the second one is the one that's used to give you a formal mark. I'm sure none of you will have any problems with that approach. The real idea of these assignments is for you to test what you know and for you to develop your learning. It's not because we're not giving a certificate from a university. The idea is not to make you um, give you an exam to see whether you can pass or not. The idea is to encourage you to write a good essay about a focused topic, um, which and that's the real emphasis here is learning slowly over 12 weeks, focusing on developing your writing skills, and then doing a final essay based on one key topic that we will have looked at. So it gives you a chance to really think about uh, what um, what you're learning. The pass mark's typically 50%. I'm just looking at the questions now. And a certificate will be issued, and that will be issued with the Expertise Institute's logo and Fenwick Elliott's logo, and I'll sign that. And of course, you'll have the record of the people that have been teaching you as well. Yes, there will be case studies along the way. Case studies will be short and simplified, otherwise they don't become they take up too long. So there will be case studies along the way, and they won't be limited to any particular region. And the idea of international arbitration is that you start to think about how this works. So, I mean, typically, um, if you take a project anywhere in the world that you're working, and if it's subject to the law of the place where you're working in, but you might well end up with an arbitration in a different place, probably very likely. If you've got ICC rules, SIAC, LCIA rules, the classic places to have an arbitration and the most well-known seats for arbitration are London, Paris, Stockholm, New York, Geneva, and then more recently Singapore. There are other places too, but the real key is how good is the legal system there and how experienced are the judges with international arbitration. And so you tend to go to locations where you have a commercial court that really understands international arbitration and judges that have decades of experience. So the Middle East, you may go to DIAC, for example, but the court system there in terms of enforcement is nothing like the others that I've mentioned. And so this is something to consider. So if you're on a large project, have a look at where your arbitration might be, because I suspect it'll be one of those key seats. And they're called the seats because that's where you go to sit and have the arbitration. But of course, you then benefit from the law of the place supporting the procedure. Good. Any other questions? So who's so far? I think some of you may have already signed up that have joined today. I just wondered who's already signed up that's here today. And how about those that are thinking of it or might? Ah, okay, yeah, thinking about it. So am I. Okay. Well, I mean, all I can really say to you is this is the first time I think a course like this has been done. And we've got some absolutely excellent trainers that have agreed to support me, first class people. And you'll be on the first course, so you're going to get yeah, you'll always be those people on the first course. It's something special about the first course. I think it was certainly the case for others that I've done, and also, for people that I meet that have been on the first course, because you're going to get that particular treatment you get first time round. And probably the number will be slightly lower because usually it is on the first course. So, you'll get an even greater chance for interactions, I would hope anyway. Any other points or questions? No. Okay. Well, I hope to see some or even all of you there. People have signed up. We've already got a cohort. So please don't leave it too long if you're thinking about it. We will cap it. We will cap the number. It is about doing this well, not just taking people on for the sake of it. And we've already proved that from our FIDIC course that we ran earlier this year, which had fantastic feedback. I suggest you have a look if you haven't seen that. The feedback from that course was really excellent, but that was because it was a small capped number of people. Oh, is there a Q&A box? Okay, one more question. Will there be I've got another question. Will there be training in judgment writing? So this is award writing. Yes, there will be training in award writing. We'll look at what needs to go into an award structure. And then one of the workshops will be about what you should and shouldn't do in relation to writing an award. Good. Thank you. I hadn't realized it was also a Q&A box. Good. Thank you. All right. Anything else? No? Okay. Well, I think probably the best thing to do is to wrap this up. If you think you've got a question later, then just submit it to the Expertise Institute or to me. You can always drop us an email later if you suddenly think of something. Um, But other than that, I urge you to have a read of the materials and have a look at the course outline, which tells you everything really that you need to know. Um, and if you are tempted, there you are. It's in the webinar chat. And there's a discount for applications before the 14th of December. So if you're tempted, please do sign up. And I'm sure you're going to have some great colleagues there because, usually on this first run, you get people that are very keen and very interested to find out more. Um, so I think you'll have a good group of other delegates with you. Very good. Thank you very much. Thanks, James. Thank you. Nora, thanks a lot. All right. Thanks very much. Hope to see you there in the new year. In the meantime, have a great festive season and a great new year. All the best to you. Thanks a lot indeed. Thank you.